Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about the banking regulation in India. Let's start with a little bit of history. The history of banking goes back to the Vedic age, where practices like usury and loan deeds were prevalent. The Vedic era and the modern era also witnessed banking activities. The first bank to be set up in India was the Bank of Hindustan in the year 1770 at Calcutta, and it was wound up in 1830 to 1832. By the year 1843, there were three main banks under the East India Company, which were Bank of Calcutta, Bank of Bombay, and Bank of Madras. In year 1921, the three banks were merged to form a Imperial Bank of India, and in 1955, the Imperial Bank of India was no longer a private entity, and it was nationalized and renamed as the State Bank of India. The State Bank is the oldest bank in India. Now let's see RBI as a central bank of the country. RBI started its operation as a private shareholder bank. It replaced the Imperial Bank of India and started issuing currency note and acting as a banker to the government. The RBI covered all the undivided India, and in order to make policies that were consistent with both RBI and the government agenda, the government nationalized RBI immediately after the independence of the country. From 1st January 1949, RBI started functioning as state-owned and controlled central bank. India also enacted the Banking Regulation Act in 1949 to streamline the function of commercial bank. RBI has mainly three functions. First being the regulator of all banks, second being the banker to the government, third being the banker's bank. Now let's see the legislative framework for the banking sector. There are various banking law and regulations which are mainly or partly related to how the bank function in our country. First being the Reserve Bank of India Act 1934. It was enacted to constitute RBI with objective to regulate the issue of bank notes, keeping reserves to ensure stability in the monetary system and to operate the nation's currency and credit system effectively. The RBI Act deals with the incorporation, capital, management of and business of the RBI. Moreover, various functions of the RBI which include the issue of banknotes, monetary control, bankers to the central and state government and banks, and lender of the last resort. Third being provisions talking about reserve funds, credit funds, audit and accounts. Fourth being the issue of directives and imposing penalties for violation of provision of the Act. Now the second act is Banking Regulation Act 1949. It is deemed to be the most important legal legislation for banks. It was initially passed as the Banking Companies Act in 1949 and it was eventually changed into the Banking Regulation Act 1949. Along with the RBI Act, the BR Act provides a lot of guidelines to the bank. They cover a wide variety of area. Some of the major provisions are the acceptance of deposit of money from public for the purpose of lending and investment. Second being the it defines a banking company as the company which handles the business of banking. Third, it distinguishes between the demand of time liabilities and the liabilities which are repayable on the demand and time liabilities, means which are not demand liabilities. Fourth being it deals with the meaning of secured loans and advances. Fifth being it dealt with the application of banking business. And the last, it specifies banking companies doing banking business in India should be at least on the word banking company and its name. In addition, Section 12 and 13 of this Act deals with the paid up capital, reserves, and other terms and conditions. Moreover, Section 18 specifies the cash reserve ratio to be maintained by the non-scheduled bank, and Section 19 Clause 2 provides provisions about the shareholding of the banking company. Section 24 specifies the requirement of maintenance of statutory liquidity ratio as a percentage which is specified by the RBI from time to time of the bank's demand and the different kind of liabilities in form of cash, gold, securities which are free of any other liabilities. The third act is Prevention of Money Laundering Act 2002. This act was enacted to prevent money and control other money laundering activities and to confiscate and seize the property obtained from laundered money. Also, It deals with any other issue related to money laundering in India. Fourth act is the Foreign Exchange Management Act 1999. This act deals with the regulation and management of foreign exchange, and its objective is to amend the law related to the foreign exchange so that foreign exchange market can be developed and foreign trade and payment increases by time. The fifth act is Limitation Act 1963. This act, deemed to be one of the most important acts in the aspect of lending, this particular act gives the power to the lending bank in taking legal action against the borrower in case he defaults on his payment. The sixth act is Recovery of Debt Due to Bank and Financial Institution Act 1993. This act constitutes a debt recovery tribunal for speedy recovery of loans, and this act is applicable to all or any bank, financial institution, or consortium of them for the recovery of debt which is more than 10 lakhs. Moreover, it also maintains the debt which is used in broad purpose. Now the next act is Lok Adalat under Legal Service Authority Act. The Lok Adalat were developed to bring about a dispute settlement mechanism all over the country. The Lok Adalat basically derive jurisdiction by consent or when the court is convinced that the dispute can be potentially settled at Lok Adalat. It is governed by the ideas of fair, equity, and good conscience, and various other legal principles. In case of the settlement, the award would be binding on the parties to the dispute. Then the next is SARFAESI Act 2002. The main objective of this act is to regulate securitization and reconstruction of financial assets and enforcement of security interest and for the matter connected therewith. And it also empowers the bank and financial institution to recover their dues in non-performing assets without the intervention of the court. The Act empowers the bank and financial institution to issue notice for recovery from the borrower and guarantors, calling them to discharge their respective duties within 60 days. Now the next act is Lenders Liability Act. This act deals with the bank and financial institution and says that they should give acknowledgement to all loan application with the receipt. The loan application should scrutinize all the application within a reasonable period of time. Lenders should ensure that the credit appraisal is properly done only after there has been an assessment of the credit worthiness of the applicants, and the lender should inform the borrower after the sanction of the credit limit that he can allow along with the terms and conditions. Moreover, the duty is to duly signed acceptance letter should form a part of the collateral security, and in particular cases of consortium advances, the participating lenders should make their own procedures to complete the appraisal of the proposal in time-bound manner. Now the next act is, in the last of this video, is Bankers Book Evidence Act 1891. This act provides direction to maintain records of bank in written format and other provisions relating to evidence. That is all for today's video. Thank you for watching. Please like, share and subscribe.